what the court did say, from my understanding, and I've had the advantage of reading the proceedings of the court, what the Honorable Justice Lehman did say is that the order made by him on the 24th of May, which according to him was served on the first and the fourth defendant, as the governor and the attorney general, on the 27th of May, is deemed to have they are deemed to have had knowledge of the order because of the fact that the order was reported in the social media. Sanusi Lamido Sanusi was not said to have disobeyed any order. So, if the order affects him or affected him, he ought to have been put on notice. But what the court is saying, I cannot declare invalid the repeal law made by the House of Assembly.
Right.
And that repeal law empowers the governor to reinstate Sanusi Lamido Sanusi.
Right.
So the order is a bit confused.
It is confusing.
But what is important, which the learned trial judge did not address in his ruling today, is the convenient way by which two solid judgments of the Supreme Court on the limitation of the power of the Federal High Court to interfere in the affairs of traditional institutions. So it cannot be done via a fundamental right application. And in two cases, Olani and Aruyehu and Emir of Togo and government of Kano State, the Supreme Court made it clear that to be a chief is not a fundamental right. It's a privilege. And so you cannot go to the Federal High Court to say my right to the stool has been violated, or as in this case, a member of the Emirates went to court to say
that his human rights have been
violated. So there are problems. So because the judge was, I listened to him. His lordship was talking of the need to respect the rule of law. In any democracy, in any country that loudly claims to proclaim to operate under the rule of law, the judgments of the Supreme Court are binding on all authorities and persons. And it's a mockery of the rule of law if a High Court judge decides to ignore or overrule the judgments of the Supreme Court. So that is the bottom line of the whole confusion.
Right.
It is whether the Federal High Court has jurisdiction to determine human rights matter arising from the deposition or reinstatement of a tradition.
And what's your legal opinion of that? What's your assessment of that?
No, in the first place. In the first place. We sometimes forget that we're operating a democratic system. Ordinarily, we shouldn't be discussing institutions that are not democratic. In the second place, we're operating a federal system of government, however distorted a federalism may be, the Constitution has made it clear that the National Assembly can only enact laws on matters in the exclusive legislative list on concurrent list. Traditional institutions, shifting in matter, are residual. Only the state governments can make laws in respect of those matters. And that is what the House of Assembly did the last time and, as it were, undid now. And so it's not the business of the Federal High Court. And part of the confusion to them, for me, is unfortunate. The orders that are oozing, out of Kano State are rather constitute embarrassment to the judicial. And once we already had conflicting order, by the way, you have the orders of the State High Court, Kano State High Court, in favor of
and that raises
Sanusi.
That raises.
So once you have that confusion, the practice in the past was to allow the Court of Appeal to clear, the confusion as it were. And in this case, an appeal has been filed in the Court of Appeal over the ruling of the court that he had jurisdiction on the matter. And from the information at my disposal, the record has been entered. Once that is shown to the judge,
he should have just
can no longer make any pronouncement.
But he still went ahead.
Well, I think that will be taken up elsewhere.
Yeah, but
it's not just the judge.
Yeah,
our colleagues who also set in motion the confusion that we witness in some of our courts will also have to be called to order.